Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry Smith Frank make all the pieces fit together.
Good morning, everybody. My name is Alexandra, and I've been with the law firm here for about 3 years now. I practice primarily in the areas of employment law, and I also do commercial litigation and recovery work. Today I'm going to talk to you about working notice of termination and the obligations of the employer and the employee in the context of when the employer decides to terminate the relationship. I'm also going to talk to you about 2 recent cases involving situations where the employee fails to work during the working notice period offered. So employers must provide reasonable notice to the employee upon termination of his or her employment, absent just cause. The primary purpose of this notice requirement is to compensate the employee while he or she looks for comparable employment. The minimum notice periods can be found in the Employment Standards Act. However, as you probably already know, usually the minimums are not sufficient and you need to look at what's reasonable in the circumstances. This is generally set out in the case law, and the courts look at things such as age, length of service, position, and comparable employment. As well, when an employer is providing or offering working notice of termination, working notice, they should also consider that the environment that it is not hostile and it's not unreasonable to expect that employer from continuing to work during the notice period. So that's another obligation of the employer to make sure that the workplace is actually going to be okay for the worker to work there. Employees also have a duty, upon being terminated from their employment, they have a duty to mitigate their damages. In the context of working notice, this duty to mitigate essentially translates into an obligation to work until the end of their notice period unless he or she opts to quit beforehand. There's generally employers get to decide whether or not you want to provide working notice, whether you want to pay in lieu thereof, or whether you want to do a combination of the two. This is, of course, subject to any restrictions that are outlined in an employment contract that you already have in place. At first blush, working notice seems ideal as it looks like the most cost-effective option. The employer reaps the benefits of having an employee work during the notice period while significantly reducing the cost of termination to statutory severance pay. However, of course, there's a number of things to consider before making that decision. Statutory severance pay, or Section 64 in the Employment Standards Act in Ontario, cannot be provided in terms of working notice. This must actually be paid out to the employee. So even though you might provide a working notice period, you still might have to pay something out. Is it reasonable? You also have to look at whether it's reasonable, like I was talking about earlier, whether it's reasonable to expect the employee to continue working. Is the environment of the workplace now going to be hostile, poisoned, or humiliating for the employee? These are things that you need to consider. Also, the practicality of having the employee continue. Do you have a replacement already? Is there actually any work for the employee to do during this notice period? Other things to consider when you're assessing the risk are the employee's length of service and seniority. A longer time of working with the employer obviously means a longer working notice period. Senior executive level employees may have greater access to confidential or proprietary data, which can be damaging to the employer if that exiting employee decides to go and work for the competition or decides to start up their own competing business. You also have to consider the relationship that you had with your employee. Are they going to leave on good terms? Are they leaving because of poor work performance? You need to decide how the employee is going to react to being terminated. Again, what follows from this is a workplace morale. How is this going to affect the dynamics of the workplace with the employees that are, not fired? Is that going to be awkward for them to work with someone who's been fired? Is this, going to create a negative atmosphere in the workplace? Taking all of these things into consideration, employers often choose to diminish the risk by terminating the employment immediately and providing payment in lieu of the notice. An issue is raised where generally an employer, when you offer working notice and the employee fails to work throughout that notice period, employers can take that as a sign of the employee choosing to quit, and then essentially would be free from paying out wrongful dismissal damages with some exceptions like statutory severance pay. However, there have been a couple of recent cases that show that even where an employee fails to work during the notice period that is offered, the employee still might be on the hook for damages. What happens if the employee fails to work throughout this notice period? Can the employer be held liable for this? The answer is yes. There is a Giza and Seychelles School Bus Service Limited is a 2012 British Columbia Court of Appeal decision. In Giza, a school bus driver was employed for about 5 years. After a dispute with his employer with shift times, the bus driver was given written notice of 5 weeks and was actually left on his bus seat. Instead of working out the notice, the bus driver took it as him getting fired and left work immediately. The court held that the bus driver was actually required to work throughout that notice period. However, the court also held that 5 weeks was inadequate notice and that held that the proper notice in these circumstances was 6 months. So in assessing the damages, the bus driver was awarded 6 months less the 5 weeks that he should have worked and that was offered by the employer. So essentially the court applied the principle that while repudiation ends the ongoing rights of the obligations of the party under the employment contract, it does not affect any rights or obligations that accumulated before the repudiation. So the court held that the bus driver's right to payment in lieu of reasonable notice had accrued when he was given inadequate notice. So just because an employee refuses to work out the notice period doesn't necessarily mean that you're not going to have to pay any damages to the exiting employee. The Giza decision essentially appears to allow an employee who thinks as though they have not received reasonable notice to effectively quit from their employment during the working notice and still be able to receive an award. This is Duchesne and Dr. Kerman Ashraf Dentistry. It's a 2002 Ontario decision. It's an appeal of a Kitchener Small Claims Court decision. Here, the employee worked as a part-time dental hygienist for about 5 years. She worked about 32 hours a week. The employer then attempted to unilaterally change the employment contract such that she would be required to work up to 48 hours per week. The employer refused to sign this new contract despite threats of being fired if she didn't sign it. The next day, the employer delivered a termination letter providing 5 weeks of working notice. The employee, too distraught to continue with her duties, she went home immediately. She was upset. She didn't think that she could continue assisting the patients in her state. The next day, she called the employer and said, I'm going to come and work out my 5 weeks that I've been given. The employer said, it's too late, we've hired a replacement, sorry, you're out of luck, essentially. Here, the court in Ontario distinguished the case from Giza. They decided that the employee's departure from work after receiving the termination letter did not show an intention on her part to repudiate the employment relationship. And essentially this finding was supported by the fact that the employee called the next day to advise that she'd be coming back to work. Also, unlike the Giza decision, the employer in Duchesne did not keep open the employer's opportunity to work out the notice period. They essentially immediately hired a replacement. This, was a big deal in the court's eyes. Given the employer's actions, the court decided that the employer cannot now rely on the fact that they provided the working notice to reduce the damages that were awarded. So in Giza, she was awarded the the 6 months notice and that was not deducted for the 5 weeks that was offered to her. It's interesting because, you can look at it on the side of the employer saying, hey, this person left, I don't think she's coming back, I have patients to deal with, I'm going to hire a replacement immediately so that I don't have to cancel appointments and whatnot. Here, you might think the employer is acting proactively to hire someone else, but in turn now has to pay an extra 5 weeks of notice. So just some closing comments. So when you're deciding to provide working notice or payment in lieu thereof or a combination of the two, you need to carefully consider your options. You need to weigh the potential for cost savings against the risks that I just talked about. If you're going to provide working notice and an employee fails to work it, as I said, you still might be on the hook for wrongful dismissal damages. By failing to work during the notice period, it doesn't necessarily mean that the employee loses his or her entitlement to reasonable notice. So if you have a situation where the employee does stop working during the notice period, it would probably be very wise to obtain a clear written confirmation that the exiting employee is not going to come back. It would also be prudent to allow the employee a reasonable opportunity to either accept or fulfill the working notice before you go around and hire a replacement. And that's all for today. Thank you very much.